Good afternoon. We're going to get started in a brief moment. I wanted to, thank everybody for making the decision to participate in this webinar. I think that you'll find this extremely helpful. I'm Daniel Bornstein. I'm with Bornstein Law, having been practicing law for 25 years, representing property managers, investors, real estate agents, brokerages in the management of their landlord-tenant disputes, and we are in a phenomenally tricky situation right now with the confluence of the unfortunate COVID-19 pandemic and multiple different statutes, rules, regulations that are now constraining how we go about landlording during this period of time. My hope is that what you will find is that I'm trying to provide some coherent, clear, organized guidance for you so that when you look at a particular situation, whether it's a Berkeley property, an Oakland property, a San Mateo property, a San Francisco property, you're in a much better position to understand what we are all facing. It's now 1 o'clock, and my hope is that we can get through this slide presentation in about 35 to 45 minutes. I'm going to be adding guidance as we go through. And for those of you who have questions after this presentation, please email them to me, and I will be glad to, as long as they're questions that can be answered by email, I'll be glad to provide you a response if in fact I can do so. I want to mention that right now we're in such an intense legal situation as it relates to landlord-tenant matters that statutes are changing on a weekly basis. Rules are changing on a monthly basis. So what I present to you today in a month may need to be revised, and it's my commitment to my clients, my friends, my colleagues, of trying to keep you abreast of the law as it evolves. So with that, the agenda today is I'm going to go through Governor Newsom's order and his most recent amendment of the order, go through the Judicial Council response. The Judicial Council is the organizing group who monitors and manages the administration of the courts, go through county updates, and then provide some post-COVID-19 strategy on how we're going to operate in an ethical, proper manner when dealing with our landlord-tenant disputes, and in particular, how we're going to go about seeing this unpaid rent that has accrued during COVID-19 and hopefully accomplish the goal of recovering some of those funds. So with that, let's commence the first slide. We all know that Governor Newsom declared a statewide moratorium on evictions for renters hit by the coronavirus pandemic. As of the end of June, he amended the executive order, and now he has permitted local governments to halt evictions of renters impacted by COVID-19 through September 30th. So we have an extension at this point in time, and what you will see is local jurisdictions taking this edict and then altering the way in which they structure their rules and regulations as it relates to their landlord-tenant affairs within their counties. The general rule is that right now, landlords are unable to pursue non-payment of rent evictions throughout the state if the failure to pay the rent is directly or indirectly related to a COVID-19 scenario. What this means is as follows. Governor Newsom declares the moratorium, issues this executive order, and then what happens is as follows. The Judicial Council of California has thereafter essentially suspended the ability for landlords to secure eviction lawsuits through the courts. So if you have a case where someone has not paid you the rent, I'm not able to file a lawsuit in the court and secure a summons in order to gain jurisdiction over that defendant. So we're all in a state of suspended waiting until this emergency order is lifted. And interestingly, the Judicial Council has issued a rule that we are not going to be able to proceed with eviction lawsuit filings until 90 days after the state of emergency is over. So if the state of emergency is over by virtue of a Governor Newsom decree at the end of August, we won't be able to secure eviction new lawsuit filings until the beginning of December. So you all have to get comfortable with the fact that we are all under a state of ambiguity and no ability to proceed with evictions. There are one big exception or two, unless there's a health and safety issue. So for instance, I was able to proceed with an unlawful detainer or an eviction action in San Francisco recently because the individual tenant engaged in arson within the building, and I was able to get the court to allow me to be issued a summons and proceeded with that litigation. That's a health and safety issue. Subletting, non-payment of rent, pets, unlikely to be health and safety issues. So we are in a situation where, but for the most egregious conduct, we are not going to be proceeding with the filing of eviction actions at this time. Also, for those cases that have occurred prior to COVID-19, and we have a court date, what has been happening is, for instance, last week I had a trial appearance and the court simply continued the matter until September. So everything is being pushed into the future. And I still don't know if even when we get to September, the court is going to be open for the ability to actually effectively handle landlord-tenant matters throughout California. Even if we're in the middle of an unlawful detainer action, I can't take a default against someone at this point as well. Also importantly, the sheriffs in San Francisco are simply not effectively proceeding with the eviction process as well. So I can only say this in many different ways, but the sum total is you can't use the courts at this point in time for pursuing unlawful detainer actions because the courts are essentially closed. Now let's go into the particular nuances of each county. Right now, Mayor London Breed, and you'll see on the side of this PowerPoint slide presentation, she has extended the eviction moratorium in the city and county of San Francisco through the end of July. And there is no expectation that all of a sudden on August 1st, it's going to be opened up. July 26th, she may extend it another month. As a result of this most recent executive order, which is the 13th amendment to the original order, termination notices such as an owner move-in termination, a relative move-in termination, they must at this point in time in San Francisco be set to expire September 30th, 2020, or you will be in violation of the executive orders. So if any of you have issues with wanting to proceed with a termination notice, be advised, I have to have that notice at this point in time expire around 85 days to 90 days away from today. It has to expire at the end of September. In San Francisco, no rent increases except for Costa Hawkins rent increases. So for those of you who have banked rent increases, hold on. One, during the pandemic, the optics of raising rents at this point in time are not really attractive for you because so many people are in crisis economically, and the city has expressly prohibited rent increases except for a limited type of increase. And then for those tenants who are not paying rent because of a COVID-related matter, you're not entitled to impose late fees in San Francisco. Rent debt that has arisen during COVID-19. So let me give you an example. A tenant in your unit has told you that as of June 1st, they're not able to pay the rent because they lost their job. Their rent is $1,000. They also on July 1st reconfirmed that they couldn't pay the rent, and now they owe you $2,000. That is called rent debt arising during COVID-19. What you need to remember is this. Of course, you can't serve a 3-day notice to pay rent or quit now. 2, the tenant will have 6 months from the date the moratorium ends to repay that COVID-related debt. And right now, that COVID-related debt, that $2,000, in the future, it will not be allowed to be used for a 3-day notice to pay rent or quit demand, but is being transitioned into consumer debt. This was a recent change by the supervisors, which means all of this debt that is arising right now in San Francisco that's COVID related, you will not be able to evict a tenant for failure to pay that rent debt. You will be able to deduct it from the security deposit. You will be able to go to small claims court and demand it 6 months from the date the moratorium ends. But for right now, that debt is going to be transitioned into consumer debt, which means it isn't treated under a 3-day notice to pay rent or quit, allowing you to evict the tenant in the future. I want to let you know that this was a new statutory change, and within 10 days of this supervisorial entry of a new statute, a lawsuit has been challenging and filed to challenge this nuance. I will promise to keep you informed of how the lawsuit evolves, but for right now, the way I am teaching it is consistent with what the statute states. The debt that has arisen during COVID-19 rent debt will not be permitted to be used in a 3-day notice to evict in the future. That's the current state of the law. San Francisco right now has 3 particular issues that are being challenged by different trade organizations, private individuals. The first one is a new rule under the rent ordinance that suggests that a Costa-Hawkins rent increase or a rent increase in excess of the yearly permitted amount, if it is deemed to have caused a tenant to transition out, and if that rent increase is issued in bad faith, a landlord could have liability for it. Right now, that new ordinance is being challenged in the court. The revised buyout agreement rules are being challenged in court as well. I promise, as I said a minute ago, I will keep you informed and up to date as to all these challenges and what ultimately happens. For right now, be careful with your rent increases. And again, with a big memory, rent increases are not permitted at this point in time, but for Costa-Hawkins. 2, be aware there are new rules and regulations for buyout agreements as of April 1st of 2020. You need to update your disclosure documentation, and you need to be very careful in drafting buyout agreements. My office has become very, very busy on a weekly basis attempting to negotiate transitions of tenancies compliant with the law, because oftentimes this is the best solution to avoid a dispute at court, especially when the courts are closed. The next one is prohibiting landlords from evicting and imposing late fees and penalties. That's what we just spoke of, where COVID-related debt is now, in fact, not going to be allowed to be used for a 3-day notice. And this whole matter is being challenged in court. I will keep you informed as things evolve. We are in a state, unfortunately, where I'm getting emails and phone calls all day long of owners who are not collecting rent, have tenants who have informed them they can't pay the rent, and I don't have many solutions for you. The best solution in San Francisco is 1, either simply accept a reduced amount and then notify the tenant that they're carrying a balance of the rent. For example, if the tenant rent is $1,000 and the tenant only pays you $800, I don't want you to reduce the rent to $800 a month. I want you to accept the $800 and inform the tenant in writing that they remain obligated to pay a debt of $200 and it is accruing over time. That way you're not resetting the base rent, you're just carrying a debt. Once COVID-19 is over, the tenant will have 6 months to pay back that debt that has accrued. That's the easiest way to handle it if you don't want to waive the rent or reduce the base rent. Alameda. So Alameda County. In Alameda County, we have, of course, Oakland, we have Berkeley, we have many, Emeryville, we have many local jurisdictions that have rent control, just cause eviction rules, and their own moratoriums on evictions. However, the Alameda County supervisors issued a rule across all of Alameda County that prohibited evicting of tenants during COVID-19, except in rare circumstances. And again, it's public safety and health. 2, you must include certain notice requirements in your termination notices if you're indeed going to proceed. And be advised, San Francisco, any termination notice that's being issued in San Francisco now must include a 2-page additional supplement regarding the COVID-19 pandemic. So you've got to stay up to date as to what needs to be provided. And of course, knowing how difficult it is to accomplish goals in San Francisco or the Bay Area, make sure you contact an attorney before you start a termination at this time. In Alameda County as well, where in San Francisco, a tenant will have 6 months to pay the unpaid COVID rent debt. In Alameda County, a tenant will have 12 months from the date the emergency is lifted to repay the overdue rent. Also, as I discussed before, you will not be able to evict a tenant for this COVID-related debt in Alameda County because the debt is going to be transitioned into consumer debt. So a tenant who has failed to pay $1,000 of rent during this COVID pandemic in Oakland, the tenant will have 12 months to pay that $1,000 back. And on the 13th month, you're not going to be able to proceed with an eviction, of course, but instead you can, 1, take it from their security deposit if it hasn't already been exhausted, or in the alternative, file a small claims action for that money. You, of course, have the right to waive the debt. You have the right to renegotiate the lease, but I'm giving you the core approaches that you can follow. Contra Costa County. Contra Costa County is prohibiting evictions of both residential and commercial property and has a moratorium on rent increases. It applies across Contra Costa. And again, there are only 2 particular reasons why you could proceed with a termination in Contra Costa: health and safety, and if we're going to proceed with a move-in of a family member or an owner into a residential unit. So in Contra Costa County, you are entitled to proceed on an owner move-in or relative move-in, and you are entitled to proceed if a tenant is engaged in violations of significant health and safety matters. The perfect example is of arson or some sort of narcotics, illicit narcotics, domestic violence, physical altercations, drug dealing. That type of stuff will still be permitted, but non-payment of rent, a small breach of a lease agreement, bringing a pet onto the premises without consent, those things are currently not going to be permitted, whether we're in Contra Costa County, Alameda County, San Francisco County, and this is the new reality we all face. Contra Costa County, again, there's a prohibition on evictions due to unpaid rent. If it's directly or indirectly related to COVID-related matter. In Contra Costa, the debt has not been transitioned into consumer debt, so we will see how it will work out in the future. There's a ban on all no-fault evictions except for owner move-in or relative move-ins. And again, there's a temporary freeze on rent increases. There is going to be in Contra Costa a grace period to pay back the rent. It's set at 120 days. This date is after May 31st, but it is going to be extended. There is no late fee for unpaid rent during this period of time. And these issues are retroactive to March 15th, 2020. We're about 4 months into this pandemic, and I can only tell you that I don't see a light at the end of the tunnel right now. What I think is there will be extensions of these rules, and we may not be able to commence unlawful detainer actions until 2021. Not sure yet, but except for those health and safety matters, I really do believe the courts are going to be relatively closed to any type of action by a landlord seeking the removal of a tenant. San Mateo County. The county has recently extended the eviction moratorium to July 28th. No evictions. Courts are not accepting unlawful detainer actions until September 1st, 2020. And I got to tell you, this is the first time in my 25-year career where the courts are closed. I can't get into the courts. Delivering documents are complex to the courts. And so we're in a situation where a core component of how our government operates is in some respects closed, and we don't have clarity as to when it's going to open up. We don't know if the moratorium in San Mateo is going to be extended. We don't know if they're going to extend the date for unlawful detainer actions, but stay informed. I promise you I'll continue to have additional updates as I learn of them and put together a revised PowerPoint slide presentation. Tenants in San Mateo County will have 90 days to repay the debt after the COVID-19 emergency is over. However, that 90 days can be extended to up to 6 months. So what we have is San Francisco 6 months. We have Alameda County 12 months to repay the debt. We have San Mateo County 6 months. So what are we going to do? And many of you are looking at yourself, looking at your tenant ledgers and saying, Daniel, I'm accruing a lot of debt and I don't have a solution. It's particularly problematic because my security deposit is only $1,000 and right now the tenant debt is $5,000. Well, you can always take unpaid rent from a security deposit. You'll have to make a strategic decision as to whether you want to use the security deposit for unpaid rent, and there's good reasons not to. There's also reasons if you have cash flow problems to take those funds from the security deposit. What I will tell you is that after COVID-19 emergency shelter in place is lifted and the moratorium is lifted, and after the 6-month in San Francisco period to repay the debt is lifted, if a tenant still owes you money from COVID because they did not pay you the rent debt, one easy solution is to file a small claims lawsuit. If it's under $10,000, that's the jurisdiction of small claims. There are numerous nuances to small claims. The big nuance is that in small claims, you cannot be represented by an attorney. I can draft up the small claims action. I can file it for you, but if you're the plaintiff and you're the defendant in a small claims action, you will not be entitled to attorney representation. Only if a defendant appeals a judgment in small claims are both parties entitled to an attorney. So what I believe is that there are going to be a lot more small claims actions in the future trying to collect some of this COVID-19 debt. I am happy to assist people in this. I don't recommend proceeding at this point in time. I just want you to know that filing a small claims court matter is not that cumbersome, not that complicated, and it may be a segue to collecting unpaid debt that has arisen during COVID-19. And it may not be until the springtime of next year where you will have the ability to file small claims for this debt. Now, what happens in the event that your debt is not $10,000, but $25,000 or $15,000, and you're committed to collecting the debt? For example, you have a beautiful condo in San Francisco. The rent is $7,500 a month, and the tenant has not paid you for May, June, July, August, and COVID has been extended through August. That's $28,000 or $29,000. It's $30,000, excuse me. COVID emergency is lifted. In September, the tenant owes you $7,500 for September, and they pay you the money. The tenant will have 6 months to pay back the $30,000. In 6 months, they didn't pay the $30,000. You are perfectly entitled to proceed in regular court, superior court, seeking a breach of contract action to collect a debt that arose. So I mention this because you're not waiving that money, it's just owed to you. Whether you collect it is a story that is still going to unfold, but you do have approaches in the law in the future that will allow you to recoup it. So I would not be so quick to simply waive debt. Instead, I just keep track of it. However, I want you to also recognize that in this situation, we have a lot of rentals becoming available. If you're reading the news, rents have come down significantly in different parts of San Francisco. Oakland rents are coming down as well. And if you have a great tenant, you may have a decision to negotiate a rent reduction, negotiate a rent waiver in order to keep them in the unit, because that may be a good business decision. I'm here to guide you and help you in those decisions, and I'm available for those consulting, because sometimes it may be better to waive the debt than to allow the debt to accrue, but it is dependent upon a number of factors, and those factors often are dependent upon what the current rent is, what the market rent is, how long will a vacancy arise after the tenant moves out? Do you want the tenant to remain in the premises? Are you willing to waive rent? Those type of questions I'm happy to guide you with. I just want you to know that we do have strategies in place to pursue that debt through the courts, even though we're not likely to be able to pursue that debt through an unlawful detainer action. The approach that I would take, one approach, would be when the debt, let's say in Alameda County, 12 months from the time the eviction moratorium is over and the emergency rules are over, a tenant will have 12 months to repay you that COVID debt. If the tenant hasn't repaid you that COVID debt, we would send a letter to the tenant informing them that the 12 months has elapsed, sending them a ledger and an accounting that they owe that debt. If they do not pay that debt, if it's under $10,000, I would proceed in small claims. If it's over $10,000 and it's COVID-related debt, then you'd have to file it in superior court. Remember though, that's COVID-related debt. If it's not COVID-related debt, which means the emergency orders have been lifted, let's say the end of September, the emergency orders have been lifted, and all of a sudden October arises, you don't have to wait 12 months to get that debt back. If on October 1st, the tenant hasn't paid you the rent, on October 2nd, if your lease permits, you can serve a 3-day notice to pay rent or quit. So our core focus is this COVID-related debt. Once the emergency is over, you'll go back to the standard approach that we have typically used, which is using the 3-day notice to pay rent or quit to capture that rent debt. Hopefully you understand this nuance. We are still not clear when the emergency is over, and when we will be back to the normal operation of how we have practiced our landlord-tenant engagement in the past. What I will tell you is this. I have thought strategically for many of you on what to do in a situation where you have a tenant who, whether it's a fault of the tenant, no fault of the tenant, they're sitting in your unit and not paying you rent. The rent failure to pay arose during COVID, but then continued after the emergency has been lifted. This is going to be a theme, I believe, that is going to occur throughout the Bay Area because we're dealing with catastrophic unemployment. And so what we will have is tenants who don't have many options, unfortunately, who are not paying during this COVID time. And then when the emergency is lifted, they're still unemployed and not paying the rent. What I need you to understand is that we will in the future be able to seek in small claims the COVID related debt, and we will simultaneously be entitled to proceed with a 3-day notice for post-COVID rent debt. What I would recommend is, of course, serve a 3-day notice for post-COVID rent debt, expect it to be paid, but if it isn't paid, file an unlawful detainer action. And while we are filing an unlawful detainer action, also proceed in the basis of trying to collect that COVID debt by filing a small claims action. At that juncture, once we filed the unlawful detainer action, filed the small claims action, my office can serve both lawsuits simultaneously. And that's one approach to collect all of the money owed. And it also puts you in the best position to have a discussion with the tenant about either voluntarily moving out of the premises, about agreeing to make a payment under a stipulation to cover all of the unpaid debt, or some other negotiation, but now you have captured all of the money. And I will tell you, this is not that cumbersome of a process. The unlawful detainer process, many of you are familiar with. Small claims, some of you will be familiar with through security deposit disputes. But a small claim filing is a 1-page document filed at the court, and then I would take the same filed document and deliver it to the tenant at the same time we're filing the unlawful detainer action. And I think in that capacity, you'll have captured all of the debt, at least in 2 different realms. 1, through the standard unlawful detainer eviction process, and 2, through the small claims action. And hopefully through that confluence, you will be able to recoup and recover the debt that is owed to you. This is an approach that I think will be warranted in many situations going forward. I'm happy to discuss it with you. Unfortunately, right now, I would not proceed in small claims for COVID-related rent debt because they have time after the emergency order is lifted to pay it back. And of course, we're not proceeding with non-payment of rent cases because the court is closed and there's a moratorium on non-payment of rent case. So right now, we are hamstrung on both sides of this slide, but come September, maybe October, maybe it will take until January, these type of circumstances will arise, and that's when I think you ought to think strategically about this. One point that's important is that we are still in our office doing many, many negotiated tenant buyout agreements where a tenant who has lost their job, has not paid the rent, has a family in Los Angeles, and they're saying to us, hey, I'd like to move back to Los Angeles. I don't have rent money. Would you consider waiving the rent money in exchange for me moving out of the premises? All things being equal, I'd rather have you have a vacant unit than a tenant in the unit not paying rent without any ability to do so in the future, negotiate deals. A vacancy at least allows you to renovate, update, and locate potentially an alternative tenant to occupy the unit. I do recognize that this is not the ideal time to go out to the market and try to find new tenants. But again, All things being equal, I'd rather have a unit vacant than a unit with a tenant in the unit who hasn't paid rent for May, hasn't paid rent for June, hasn't paid rent for July, and is not paying rent. In that situation, I would broach the subject of a buyout. I would comply with all of my statutory disclosure obligations, whether I'm in Berkeley, whether I'm in Oakland, whether I'm in San Francisco. I do have obligations of disclosure for buyouts. My office can provide you those disclosures and then get to a deal. And why? Because again, a transition of a tenant without having to go to the courts that are closed and gaining a vacant unit is preferred than having a tenant not paying the rent. That's different than a tenant who's paying a part of the rent. So if the rent is $1,000 and the tenant is willing to pay $750, assuming $1,000 is the market rate, you may be better off accepting 75% of the rent than trying to actually get the tenant out, only to have it sit vacant for 3 months because there's so many units that are going to be available on the market. Again, I am both an attorney, but I'm also a business person. I'm a real estate investor. I understand the confluence of all of these factors, and I'm happy to provide consulting for you. I want you to know that now is still a good time to negotiate voluntarily agreements for tenants to transition out of the premises. We're doing that. There's nothing in any order by Governor Newsom or any local ordinance that precludes you from properly, ethically negotiating a voluntary move out from the premises. We're here to help you. Primarily, these 8 questions need to be answered in order for us to be able to prepare the necessary surrender of possession agreement. With this information provided within approximately 48 hours, we can provide you that guidance. And again, if a tenant is able to transition out, do so, especially if they're not able to pay the rent. I want to let you know that it's my pleasure to provide you all of this information. I am committed to ensuring that this information is kept up to date. I've never been in a more stressful environment where laws are changing, updated PowerPoint slides need to be made, and that every day there's a new situation arising that is creating a new risk proposition for owners. We are in this together. My hope is that this information provides a good core understanding of what we're faced with. And I can only tell you that since April, much of the work I'm doing in my office is commiserating with people, empathizing with people, being sensitive to the stress that you're facing, but not have many solutions for you, because the business location where I usually do my business, which is my office and the courts, well, my office is open, kind of, but the courts are closed. And so I can't accomplish goals as easily for you as I had in the past, but I can provide you guidance, consulting, and keep you informed of what you can and what you can't do. And so if any of you have a nuanced situation, please let me know, email me, and I'll hop on a phone call and provide you what I can. Thank you for participating. Again, what I would tell you is that we are in a very atypical situation. In 25 years, I've never been in a situation where the courts are closed, never been in a situation where there are no jury trials, where there's no clarity as to when things are going to arise. And all I can tell you is there are strategies, but most of them are about deferment of debt, delay of debt, keeping track of debt, but not actually demanding it at this juncture. I will be posting this presentation online and also delivering it to you. And if anything I said conjures up a question or two, please email me. I want to thank you for your attention. I want to thank you for the support that you've given. I want to make sure that everybody stays safe and healthy as best as possible. And I will continue to provide updates as updates are necessary. Thank you very, very much. I appreciate it. Have a wonderful day and stay healthy.